Sean, just a note, at some point, I just realized that we're recording. I may go off camera for a bit when your presentation is happening.
All right, not a problem.
So 6 persons are in so far. So should we start, or are we awaiting other persons? Kavita?
We have a few more persons to come in. We could just give them about 2 more minutes and then we can start.
And you will start off, right, Kavita? Right?
Yes, definitely.
Thanks.
Good afternoon, everyone. My name is Kavita Chanka. I am the manager of operations and stakeholder relations at the Trinidad and Tobago Coalition of Services Industries. I would like to take this opportunity to welcome all of you to this webinar this afternoon and on conflict resolution, dispute resolution with Dialogue Solutions. I want to thank everyone from Dialogue Solutions for engaging us throughout this process and agreeing to be part of what I hope is going to be a very dynamic session for you, the participants, as we learn more about the opportunities available through alternative dispute resolution in the workplace and in particular for SMEs. I am now going to hand you over to Christiane Hope to take us through today's session. Thank you.
Thank you, Kavita. Hello, everyone. On behalf of Dialogue Solutions, we would just like to thank you for being here with us today. We are so happy to discuss all things ADR with you. And we're hoping that at the end of this session, this brief session, you can appreciate its benefits and to you and to your organization. So again, my name is Christiane Hope. I am the operations coordinator for Dialogue Solutions. And Dialogue Solutions is an independent, non-partisan entity established to provide and promote alternative dispute resolution services. So that's mediation, arbitration, adjudication, and expert determination in Trinidad and Tobago and throughout the Caribbean. So we have over 50 certified mediators and arbitrators on our roster with specialties in areas of industrial relations, contracts, consumer disputes, maritime, oil and gas, construction, medical negligence, personal injury, and family disputes as well. So the persons we've asked to speak on this interesting topic, they are also members of our roster. So I will just introduce them. I'll start off by introducing Senator Vera, who unfortunately could not be here with us today as he was asked to attend to something urgently. He does, though, extend an apology to the audience, but he did think it was important to still share what he had to say. So we have a recording that we will play during today's presentations. So Mr. Vera, he's an independent senator. He has been practicing law since 1983. He in civil, industrial, family, and criminal law. He is also a graduate of the UWI Faculty of Law, the Hewarding Law School, and the Institute of International Relations, and is a certified advanced commercial mediator. He also serves as a director on the board of Dialogue Solutions Limited. Mr. Vera is counsel to many performing artists and is legal counsel to the National Carnival Bands Association. He has also worked extensively in the field of intellectual property protection, beginning as a member of the ad hoc committee established to review the intellectual property laws of Trinidad and Tobago in 1993 and continue up to 2010, when he served as a member of the committee constituted by the Minister of Legal Affairs to make recommendations for the protection, commercialization, and intellectual property management for the sports industry. We also have Siraj Gajda. Mr. Siraj Gajda was the former CEO of Dialogue Solutions. He is an internationally trained experiential facilitator, having received training from the Stuckey Leadership and Team Development in Switzerland. He possesses an MSc in Mediation Studies with a focus on workplace and corporate conflict resolution. He has extensively trained both the public sector and private sector in conflict management and effective communication techniques. And last, but by no means least, we have Ms. Shan Gray, an independent arbitrator, mediator, and lawyer based on the island of St. Lucia in the Caribbean. She has over 20 years of experience advising clients on a wide variety of commercial transactions and disputes with specific expertise in construction law. Shan regularly acts as an arbitrator, adjudicator, and mediator in ad hoc institutional, international, and domestic arbitrations in both civil and common law jurisdictions. She is passionate about education. She not only co-founded the Caribbean ADR Initiative, a nonprofit promoting the use of ADR in the Caribbean, but is a past chair and current education director for the Chartered Institute of Arbitrators, Caribbean branch. Both these roles have afforded her the opportunity to share her expertise and experience with other Caribbean professionals with the view to building capacity in the region. Yes, I had a mouthful to say there, but I'll let you take over, Shan, because I know that we will start off with Shan's presentation. So you can take it away. Thank you, everyone, for taking me on for like 5 minutes.
Thank you, Christiane. And I first want to thank the Trinidad and Tobago Coalition of Services and Dialogue Solutions for inviting me to speak today. This isn't the first time that I've worked with one of the coalition of services in the Caribbean. And as a service provider myself, I appreciate many of the issues faced by companies whose businesses don't revolve around tangible products. Service providers trade on intellect, and these are much harder to price. More often than not, the prices of our services is dependent on the demand for the type of services we provide and the extent to which the market considers us a leader in that market. Now, this is the position in theory. In theory, if you are the best architect or the best real estate agent, you should be able to charge the highest rate. And certainly this is true in many sophisticated large markets where one can capitalize on the existence of large businesses who are prepared to pay a premium for quality work by innovative thinkers. Unfortunately, the position is slightly different when one is operating in a small nation state, particularly in the Caribbean, which is relatively far from larger economies with which we could potentially ply our wares. Now, sadly, just the decision to do business in the Caribbean comes at a much higher operating cost. So the service industry is already working with one hand behind their backs. And to make matters worse, our clients operate in the same reality, so that even if they want to pay a premium for a high quality product, they simply don't have the financial reach to do that. And this unfortunately sometimes creates a market where lowest price wins the work, even if the lowest price does not necessarily produce the best service. And the race to the bottom of the barrel is a reality every single service provider faces. And sadly, this is not a reality we are taught to deal with in our education or training. Certainly when I decided that I wanted to become a lawyer, I went to university to learn the law And this knowledge would become the basis for the provision of my services. I then went to law school, and there I learned how to apply the law to specific circumstances. And whatever service you provide, there is an element of acquiring knowledge and understanding how to apply that knowledge to a client's needs. Now, unfortunately, in most instances, service providers are taught this application of knowledge to facts in a very sterile environment, which does not mimic real life. For example, at law school, I was given a set of circumstances and asked to draft a contract, and my grade would depend on how well I covered all of the issues which affect my clients. The better I protected all of my clients' interests, the better my grade. So, and by default, I think because of this type of training is not unique to law, all professionals and service providers are taught in this way without necessarily being given an appreciation for the reality one faces on the ground. Now, this certainly was a wake-up call for me when I went into private practice. As trained, I would seek instructions from my client and draft a contract that would cover all of the issues touching and concerning their business. What I didn't take into account for was my perfect contract being subject to opposition by the other side. Now, in the early part of my career, I represented clients who had the commercial leverage. And so negotiation losing did not fall within the scope of my experience. But that quickly changed over time and taught me some really valuable lessons about the real world, which I was able to now apply when I am working for clients, whether it's as counsel or as an arbitrator. A case I think which stands out the most in my mind was a developer who was procuring wind turbines for a wind farm development from a German supplier. And at the time, these turbines were in high demand, which gave the Germans the power to dictate terms. And my client provided me with a copy of the contract, and I happily advised as to where all the pitfalls were and provided a revised draft for negotiating with the supplier. Alas, most of the amendments that I had submitted were rejected by the supplier, leaving my very young, fragile ego fractured. But I learned a very important lesson, and I had to rethink how I worked for clients. Instead of trying to draft or amend a perfect contract, I had to understand my client's business and the role of this particular transaction to its success or demise. And with that understanding, we can then discuss what risks they can and cannot accept, taking into account what the other side was prepared to accept, and then drafted a contract in that light. And if I can be 100% honest, sometimes that contract was a shitty contract, but my client got the best shitty contract for those given circumstances. And very often at service providers, these are the types of risks that we take. You don't get to get the perfect circumstances, and some risks you're just going to have to take as a reality, accepted reality of being in business. Now, I know this is not what most service providers want to hear, and that you are quite possibly hoping that I would provide some sort of insight which would double your revenue. But I think most of us working in the Caribbean accept that from a commercial perspective as a service provider, there very often is little that you can do by way of negotiating fees and what needs to be done for those fees. And few of us have the luxury of the German supplier to be able to say, no, 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 take it or leave it. I think certainly within the Caribbean market, most of you are probably securing work either by formal or informal bids, in which you are competing with other companies who are prepared to go as low as they can to get the work. And often the quality of your service differs substantially from your competitors. But all that matters in these bids is that you get to the lowest price, even if it means that the client is going to spend more money down the road. And while this is the reality, and while sometimes we do have to accept the shitty deals, that does not mean you have to let the shit hit the fan. And I know that that might be a bit of a crude example, but I use it because sometimes the analogy really hits home, and it's going to when I give some of the examples later on. And in truth and in fact, that is what arbitration and other forms of ADR are intended to do. It limits the amount of damage, or it limits the mess when the deal goes wrong. And don't get me wrong, all service providers hope when they're signing a contract that the identified risks will not affect the transaction, that there will be no delays due to weather or price increases due to inflation. There won't be a pandemic which shuts the entire world down for 2 years. You hope that your client is going to pay on time and that all your employees are going to perform according to the terms of the contract. And in instances where these things don't happen, where you do have problems, it is hoped that you can negotiate an agreement settlement, which does not result in an aggressive dispute between the parties that has to escalate some form of ADR. And, you know, it is, while we certainly hope, and very instances this is the case, there is a reality that sometimes it doesn't go that way. In all of these instances above where things go right, and this represents the majority of your businesses, you are likely to either make a profit or break even. However, in circumstances where these things don't happen and all the risks which your lawyer highlighted come to pass, a profit or break even situation is unlikely to occur. And I think this is the inconvenient truth. But seldom will a party to a dispute ever recover all of their losses. I certainly have not seen it in the over 20 years that I've been in practice. At that stage, the issue is not really whether you're going to lose money. The question is simply how much. Arbitration and other forms of ADR come into play when the process has gone wrong and you're now trying to mitigate the damage. And the role of arbitration and other forms of ADR, including mediation, is to minimize those losses. Now, these forms of ADR or dispute resolution are a way to provide a way to, for lack of a better explanation, sort of clean up the shit and keep it contained before it hits the fan, so that your worst case scenario does not result in your business going under. And certainly I know there have been several instances with hurricanes and economic downturns and pandemics where businesses have gone under simply because they could not withstand the pressure of these external factors and the impact that they have on their business. And disputes are similar in that respect. They can have a similar effect on your business, and ADR gives you a chance to limit that loss. Now, having said that, the question then is, well, why is arbitration, you know, more important or more better process than court? Because more often than not, if the parties say nothing about how the dispute will resolve, they're going to go to court. And very often people say, well, tell us what the advantages of arbitration are. And I could do that at this point, but I have found that this is not particularly helpful in driving the point home. So instead, I'm going to provide a list of fan-induced, splatter everywhere situations, which I unfortunately suspect that will ring bells and trigger many of you who have probably experienced these sorts of situations. So my apologies in advance. But the reason I'm doing this is because I want the business people to understand in real terms what arbitration and other forms of ADR have to offer. And I'll be speaking specifically about arbitration, but I know in Anthony's presentation, he will talk a lot about the value of mediation, because certainly that's your first port of call when a dispute arises, and it provides very good value for money. So the first case I want to talk about is a construction dispute. And my client was a contractor who was engaged by a Caribbean government to construct a water and sewage treatment plant. And under the contract, my client was obliged to construct the works in accordance to a design prepared by the government consultant. Now, unfortunately, there were errors in these designs, and the errors resulted in delays to the work. And this was exacerbated by delay due to weather and late payments of monthly certificates and a whole host of other things, which sort of interplayed throughout the construction project, some of them overlapping, unfortunately. Now, under the contracts, disputes had to be referred to court, and that we did when the government refused to settle the claim, which totaled $5 million. Now, the case itself took 5 years to get to trial, and then after the trial, it took 18 months for a decision. And arguably, the cost of the court process was cheaper than arbitration because my client did not have to pay for the arbitrator, the institution, or the additional fees associated with the hearing, which you commonly have to pay with arbitration. However, they did have to wait a very long time to finally get judgment. And sadly, when the decision did come, it was for 2.5 million, not the original 5. And in the judge's decision, it was the court agreed with our arguments relating to liability. They agreed that all of the issues that had occurred were the fault of the employer. However, it was clear from that decision that the court did not understand how we calculated extensions of times. Our client had to prove the number of days of delay caused by several events. And sometimes that is a lot easier said than done. Now, if the judge was an engineer or a quantity surveyor or a lawyer with construction experience, he would have been able to understand the evidence, including some of the assumptions that were made and the formulas we use for calculating costs. But of course, this judge was following very hard evidential rules, and that made it difficult for us to prove these losses. Now, because the judge didn't understand, he took the split the baby approach, which meant that my client got half of what they claimed. Now, after having waited all that time, you could imagine that my client was very disappointed. Much of the project was initially funded through loans and overdraft, which he struggled to pay during the 6.5 years he waited for judgment. And then during that time, he got into this Peter to pay Paul situation. And if I'm very frank, almost lost his family home. And he barely escaped liquidation, and he did so through a merger with a larger company. And all in all, I think it took about 4 or 5 years for him to fully recover from this unfortunate situation. Now, had this matter had gone to arbitration, my client would have paid 20 to 30% more in arbitration costs because he would have had to outlay money for an arbitrator, which he would not have to do if he went to court. He would have to outlay money for the hearing rooms and for an institution to administer, and all of that would be actual costs that don't exist with court. However, he would have been able to have a say in who the decision maker was, and he could have decided to choose someone who had construction expertise. And he could have also chosen rules that allowed for a flexible way of proving the case that is more consistent with how the construction industry operated. Now, I know businesses like math. So if you compare 6 years to get 2.5 million for litigation fees of 50,000, as opposed to 5 million in 2 years for 65 million, I feel confident in saying that most businesses would prefer the latter outcome. Now, I know there are some realities around this, which is Shoshan, all well and good. You are absolutely correct. Arbitration does cost less when you look at it in the long haul. However, I still have to have that $65,000 when I start. And if I don't have it, it doesn't matter if it's cheaper in the long run. And certainly, I know this is a challenge that a lot of businesses in the region face. And I think it's something that we are certainly in Cadbury working with the other stakeholders in to try and find ways to reduce the cost of arbitration. And that can be done if you use the process strategically and use the various tools that are available. So the next example is slightly different. And to protect my client's identity, I'm going to keep the details very, very vague. So my client produces a product which it successfully marketed across the Caribbean. Manufacture this product, they need parts which are supplied from a company outside of the Caribbean, far, far away. Now, for many years without incident, they have been ordering parts and using them without any incidents. And as luck would have it, Murphy's Law being what it is, on the one occasion when they secured one of their largest orders from a very lucrative client, the parts that were supplied to them by the company far, far away were defective. And this, of course, resulted in the product being defective. So this, in all of this situation, my client loses its largest client and they have to pay damages. They in turn sue the company Far Far Away in their Caribbean island. Since the said company wasn't on the island, the process for notifying them was expensive and took a long time. It wasn't 6 years and 6 months long, as in the previous scenario, but it did take over a year for them to get a court judgment. Now you would say, okay, great, this is a happy ending because they got a court judgment in just over a year. Good news, because arbitration is 2 years, so surely this is a good thing. Well, sadly it wasn't, because with that judgment, my client now had to go to try and enforce it against said company Far Far Away. Off they went with hopes of at least getting some money. Money had to be spent by them, however, to find the company and then find the assets, many of which were dispersed over 4 different countries, 2 of which did not have enforcement treaties with the Caribbean island from which the judgment was obtained. This meant they had to hire lawyers in those countries, engage in costly litigation, and when it was all said and done, in order to get the matter over and done with, my client ended up recovering only about half of what they were owed. And as I'm sure you can imagine, they had to find another supplier as the company from Far Far Away was not too keen on continuing to supply parts from someone who had sued their business. Now, had the contract had an ADR clause with arbitration and mediation, my client would have been able to settle this matter more cost effectively because because firstly, they would have facilitated some sort of discussion with the other side in the hopes of not having had to start the proceedings, get to the dispute level in the first place. And if that didn't work and they did get to the point where they had an arbitration award, they would have been able to enforce that because the country Far Far Away, or all of these countries, were signatory to the New York Convention, as was the Caribbean country from which they originated. That meant they would have been able to enforce that very easily because there aren't as many challenges, and several, over 176 countries are signatory to the New York Convention. So I use those 2 examples because they highlight 2 of the benefits of arbitration, which you cannot get in court. And that is, first of all, speed and expertise, which I've combined as 2. And the second is enforceability, particularly when you're dealing with parties outside of your own jurisdiction. So now that I've told these 2 tales of woe, you may be wondering, and justifiably so, well, Shan, if arbitration is so good, then why isn't everybody using it? And the answer to this question, to my mind, is twofold. Firstly, many companies do not have the initial capital, which I mentioned before, to fund arbitration, and therefore cannot afford the benefits of the process. And secondly, many companies fail to use the process properly, making it just as costly and lengthy as court proceedings, or they do not explore the possibilities of using less costly forms of ADR like mediation and negotiation, which will be addressed by Anthony in the next presentation. Now, there is much that can be done to address these issues, and Cadrin is working closely with the stakeholders in the region, including Dialogue Solutions, to sensitize the business community on how they can leverage ADR as a means of dispute resolution. And certainly this form of public sensitization is one of the steps that we're taking. And I think the next step is to provide practical guidance to help businesses understand how they can achieve real results when using ADR. So I certainly know that Dialogue Solutions is doing quite a bit, both in Trinidad region, to provide the training needed. And we look forward to working with them in any way that we can to achieve those objectives. So I will hand back over to you, Christiane.
Thank you, Shan, for your presentation. So I think that segues nicely into Anthony's video. So Siraj, you would go next, right? You would go after Anthony.
Yes, Christian. I was wondering, simply because I'm looking at the chat, Sean, I don't know if you would mind. There's a specific question based on your presentation. If you would mind providing an answer to the question before moving on to Anthony's recording, or would you prefer to wait to the end? Sean, your mic is on mute.
I'm sorry, I said I wasn't looking at the chat, but I can answer it now. The question that's been asked is, what can we do as service providers to protect ourselves or to be proactive in contracts? If I had to say one thing, I think the first and most important thing is to understand the dynamics of your business and how that particular transaction is going to affect your business. A lot of my clients don't do that. And they're chasing the dollars, but then they're not looking at what does this look like holistically. All they're looking at is how much I'm going to get. So I am going to be providing a real estate. I'm going to be selling real estate for thing of an example, and I'm getting 2%. So I know I'm getting 2% for providing the service, but have you looked at what the other terms are? Are they requiring you to put forward the money for all of the marketing? What is your liability? How long do you have to sell? And these are all the terms that are in the contract that people generally don't look at. And what, in not looking at it, what you don't understand is what is the real cost? Because while you may be getting 3% commission, if you are obliged under the contract to pay all of these, the marketing, that substantially reduces your profit margin. And sometimes the sort of risk that the other side is asking you to take on just makes the transaction a bad deal. So I think it's sitting down and understanding commercial risks and not just looking at the figures, but looking at the contract holistically. I think another issue, which a lot of, and I know I'm going to be unpopular for saying this because I'm saying this as a lawyer and it seems a bit self-serving, but I tell a lot of my clients, you are better off paying for advice on the contract end, on the signing end, and before you sign a contract, than afterwards. And I've had quite a few clients when they do get into it, I say, look, let me see your contract before you sign. He said, oh, no, you're a lawyer, you're just trying to collect money from me. And I said, look, the truth of the matter, and this is going to sound uncomfortable, I can confidently sit here and say that if you don't pay for the advice on the front end, there's a strong possibility you're going to pay 2 or 3 times the amount on the back end. Now, I know there is a practical reality. Look, there's certain fees we just can't afford. We can't afford to have a lawyer check every single contract. And that I agree with. However, what you can do is sit down with a lawyer and have a conversation with them about what the type of businesses you do, what type of contracts do you sign, what are the key issues that you need to look at. And once you know that, you can have an itemized list, which I've done for several clients, where you say, okay, these are the things that I must check. And if you have the experience for those, then you may only take particular issues to your lawyer that are particularly complicated because you know what the core ones are. And when you see one that isn't familiar, then you can say, okay, I'm not going to take this whole contract to my client, as some clients do. Here's my contract, tell me if it's good. And that's not helpful. Whereas you can say, here's my contract, this is what I'm expecting to get about. These are the issues that I'm concerned about. These are the risks. Advise me on these risks. That is going to be by far more cost-effective way of ensuring that you protect yourself in advance.
Sean, if I can just add on to that, I think you make an exceptional point in terms of preparing beforehand, because one of the things that we also reiterate, and we use the analogy of marriage. The proposal, when you receive a proposal, it's wonderful and something to celebrate. During the marriage is always nice. When the divorce proceedings hit, however, yep, to use your term, that's when the shit hits the fan. So we, in terms of the one of the areas that you can specifically look at as well too from a proactive manner is the type of dispute resolution clause that you have in your service contract. Far too often, there are generic cut and paste dispute resolution clauses that if you lack power, for example, and your bargaining power is lower, you oftentimes tend to just, agree to whatever the dispute resolution clause is without failing to realize that in an arbitration, for example, I mean, we've had the experience where there was an arbitration clause and the jurisdiction and seat was in London. And it actually, so there was an oversight. Person didn't think anything about it before. Again, proposal, marriage, all fine and nice. When it came to the divorce proceedings in that situation, and it's a commercial contract here, it was far cheaper to concede rather than pursue the arbitration. Because if the seat and jurisdiction is in London, then you are required to participate in London, hire someone who is familiar with the jurisdiction, the legislation, and the arbitration process specific to there as well too. So the cost overruns. It can get overwhelming at times. So one of the specific clauses one of the specific things that you can look at is the dispute resolution clause. Now, there are some sample clauses that I know Dialogue Solutions has some. Sean, I think the Caribbean ADR initiative has done some work on sample clauses as well. And there are a lot of model ADR mediation clauses within the Caribbean context. If you do a quick Google search, those are some of the things that you can find. But getting back to Sean's point as well, more often than not, having an attorney look at these things, look at the clauses, actually saves you much more in the short term versus the expenses you would spend in the long term.
Yeah. And I have found, Suraj, that in fact, the dispute resolution clause is one of those provisions where you're less likely to get pushback even when the person has leverage, because they want to give you a bone. And if what they're giving you is this, all right, let them have dispute resolution because we've got the money. So if you know you have no leverage on those, at least know you have a protected backstop. Mm-hmm. And as you mentioned the point about marriage, I'll just give this story because it's a Trinidadian one. Just to say that another error people make is that they don't want to have the uncomfortable conversations. And I remember I was working for a client who was procuring a fairly large construction project in Trinidad. We were sitting down negotiating the terms. We were talking about insurance. And the contractor was giving us a hard time. And I said, look, we need to have some insurance. And he said, look, I don't see why we need all the insurances. So I said to him, what if an employee comes in, lights a match and burns the place down? And he looked at me and said, oh gosh, girl, we even put a brick in the ground already. Look, you burned the whole place down. And you know, when you say them things, bad things, well, and he went on and on and on. And the truth is, at that point, when you're entering to the contract, everybody sees the amount of money they're going to make, the building they're going to have, the product that they're going to be able to sell or they're going to be able to use. And they're not thinking about what will happen when things go wrong. And they don't want to have that conversation. And I think it's important to have those conversations of what are we going to do when things go wrong? Because that's how you're going to see how the person is going to react. And immediately the client knew this is somebody who's going to panic when things go wrong. Mm-hmm. They're going to put their head in the sand when things go wrong. I know that that's what I'm dealing with. Then you need to operate accordingly. Yeah.
Quite correct. Chris, your mic is on mute as well too, Christina.
Oh my gosh, 2 years of this pandemic and I can't manage when I'm not on mute and when I'm muted. Okay, so I'm just gonna play Anthony's video. I'm just gonna cut the beginning part of it though, but yeah, I'm just gonna play this video. Are you all seeing it?
Yes.
Raj isn't like that. His face is first on.
I don't. That was I was now going to make a comment on that.
But don't watch the face, y'all. Just watch the words. Just listen for the words. Let me know if you all are seeing it clearly.
Yeah. So Anthony, sorry. Let me start off if you permit me.
It's kind of sticking on my end. Are you all seeing it?
You felt that it was important to.
Just confirm with me, y'all. Are you all seeing it clearly?
I am hearing the audio, but the video is not
Okay, I'm just gonna take off my audio.
you felt that it was important to do this recording. Why do you think that it was important?
Well, obviously, because we are talking about the service sector, and they play a very important role in our society and economy. I know how vulnerable it can be when you're a professional working on your own, and it's not enough to be technically skilled in the area in which you practice. You need to have soft skills. And unfortunately, in our education system, we're not trained in those soft skills: how to listen, how to communicate, how to diffuse conflict. And so I thought that this was a great opportunity to kind of shed some light on this mysterious area and what's it involved, and how people can take away something that they can really use in not just their professional work, but in their family life, in their social life as well. Yeah. So, I mean, I recognize that the coalition is the voice of the service sector, and we're talking about professionals, whether you're doctors, nurses, lawyers, talking about small business, creative and cultural industries, exporters, importers, distributors. You know, you're gonna encounter conflict. Conflict is inevitable. It occurs in all human relationships. And when you're facing a situation of conflict, what are your options? You know, you can fight, there's flight, or you could communicate. Now, we know that when conflict is handled poorly, it can be very destructive. But what we sometimes forget, that if you handle conflict well, conflict actually has the power to generate creativity, to come up with solutions, to move to next level thinking, and even positive transformation. So it's unrealistic to expect that you will be able to go on in your professional lives without encountering conflict. The key is not to get rid of conflict. The key is how to handle it in a positive way.
So, Anthony, you used a lot about buzzwords in terms of the conflict can improve creativity, it can lead to transformation. And then you went on to say it's about how you manage the conflict itself. So what would be your advice in terms of some of the tips or techniques that members from the service industry can utilize to sort of navigate how they deal with conflict, how they can because we are dealing with service providers, so they have a group as their client's perspective. How would you advise sort of
Question. So we limited fight, and fighting could be ranging from arguments or litigation, because litigation is basically very high-powered fighting in a courtroom, but it's warfare nonetheless. And I can tell you, having represented whether it's shareholders or business partners in disputes, after you go through a round of litigation, you don't want to hear that name again ever. You don't want to see them. So it's really so we're talking about communication. And what are your options? Well, we're talking about negotiation and collaboration. And that's what ADR is about. It's all about dispute, help navigate your way out of conflict towards something that is sustainable. Because the idea of these ADR procedures is to preserve the relationship, yeah, to make it even better if possible, and to avoid expensive, protracted litigation, and to avoid, you know, of the relation. What should be a last resort? And so when we talk, which is really what I know, arbitration, we could talk about that a little later, because particularly like in the sports sector and in some commercial agreements, you have arbitration clauses where the parties elect to go to arbitration. Arbitration is very much like a court process, and we can talk about that. But for the moment, let's talk about negotiation and mediation. The beauty of mediation is that it focuses on commercial solutions, a realistic resolution of the problems at hand. And it allows to have a direct input into the solutions, which they then will tailor needs. If I could, let me make some comparisons between mediation and litigation, right? Traditional litigation, it's not flexible. You know, it's all process driven, statement of case, defense, reply, then you go into all of the procedural aspects. It can attract unwelcome publicity. You have little or no control over the outcome or the judgment because it is all in the hands of the lawyers and the court.
Mhm.
It's a win, lose, or lose proposition, because many times you could win your case and still end up getting nothing, an
Right.
empty judgment. And it can be unpredictable. That's our litigation. But mediation is a lot more satisfactory because it's more time effective. You schedule it when it's convenient for the parties. It has the possibility of preserving the relationship. It's confidential. It's self-representational. This is a big issue because a lot of times when you are in court matters, the parties don't get to speak. All the talking is done by proxy through the lawyers. But sometimes, and I've seen it where people say, but I never got a chance to really tell my story, you know, because, and again, in litigation, you can't tell your story because there may be an evidential objection,
Mhm.
you know. But in mediation, you get to represent. The process requires you to tell your story, to vent, to say how you really feel. It's a wonderful thing. I think it's very therapeutic, if only for that. It's non-adversarial. So a mediator is going to try to diffuse. He's not there to referee a conflict. He's there to resolve a conflict. So the nature of the process is non-adversarial. And the end game is to come up with a creative and long-lasting solution. I mean, if you really think about it, this is a far superior way of handling conflicts for young professionals who may now be starting out, don't need the bad publicity, don't have the kind of money for expensive, high-priced lawyers. Yeah. So I would see mediation being especially helpful in cases dealing, for example, like with intellectual property, a big issue for those involved in the creative sector, dealing with consumer complaints. So for example, in the service sector, you might be a restaurateur, you might have a hotel or small guest house business. Even if you're a professional lawyer, dentist, doctor, how you handle a complaint could make or break your business.
Mhm.
Yeah. Succession issues. We know all the time about people, you know, the main entrepreneur or the driving force behind a particular business. When that person dies, everything busts up. There's been no succession issue, and mediation is a way that you could help resolve these things in a way in which it's not totally destructive. Breaches of contract, deals going sour, disgruntled employees.
Mhm.
All of us will have employees. We know about good industrial relations practice and the need for communication. Late payments or purposefully withheld payments. Mediation allows the parties to meet the mediator can meet with the parties together or separately to discover the essence of the disagreement. It allows each party's concerns to be heard without anyone shouting them down.
Mhm.
You know, or blocking them from saying what they need to say on the grounds of evidence or rules of procedure. It allows for feelings, it allows for emotions to be vented.
Mhm.
So mediation allows for everyone's concerns to be addressed. Both sides get the opportunity to be heard.
So Anthony, if I could just jump in here with a question. So you've mentioned a couple of times the therapeutic nature of mediation. What would you say to someone who comes and to you and says, listen, I don't want to deal with Siraj anymore. I don't care about the therapeutic nature. I don't care about being heard. Siraj has $10,000 for me and I need Siraj to pay me my money tomorrow. How would you advise them to treat with a situation like that?
Right. The first thing I would do is I say, okay, let's be strategic. How do you get your money from Siraj? We can send a threatening legal letter. We can sue him, but then you'll have to spend more money perhaps to recover the money that is owed to you. And even if you do get a judgment, that still doesn't mean that the judgment will be honored. You might have to bring enforcement proceedings. That takes time and money. You could ask Siraj nicely, but he may just ignore you.
Mhm.
Or you could threaten litigation and ask for mediation as a soft alternative.
Right.
All right. Now, when you are looking to resolve, what are the key things we want to do? Well, the mediator is not going to take this thing as, okay, Siraj's own money, you must pay. In the mediation, we know that's your objective. But the mediation now, when the two parties are together, the mediator may want to say, well, why aren't you paying Siraj's money?
Mhm.
Is it that you don't have the money? Is it that he wasn't satisfied with the work? Is it that there's something else? You know, there may be a reason
Right.
that you, if you were to sue, you'd only find out in the course of a defense.
Mhm.
But I would say when it comes to resolving issues, these are the big tickets. Interests. The mediator is going to keep the parties' interests and clear focus in front of them to encourage good decisions.
Right.
Options. The mediator is going to try to be creative. He's going to try to be resourceful in developing a range of possibilities. So, for example, let's say the guy has no money. You say, okay, but he admits to debt. You say, okay, well, can you maybe settle this in kind? Or is it that, well, Siraj needs money, he doesn't need in kind, but perhaps we can come up with an agreement for scheduled repayments and add in some interest. But the point is, the idea is, and you don't do this in court because court is you're zeroing in, you're narrowing down, it's all legal issues, but in the mediation now, let's explore options to see what's a win-win. And then consequences, that's always a big element. So for Siraj, it would be, what would happen if you go to court? You know, you think through the process, you tell your counterparty, what happens if you don't pay Siraj? So you have to have the parties consider the possibly effective each option before they reject or accept offers on the table.
Right.
And of course, well, in mediations, we often encounter impasses. And so the mediators are trained to be alert to these impasses, how to intervene, how to clarify, how to change directions when the parties dig into positions. So the point I'm making here is, yes, in a conflict, you could go to the court, and in the court, it's going to be a case of facts and law. But in a mediation, you have a chance to explain your story and see if you could resolve it in a way that is satisfactory to you. And nobody can make you agree to anything. In a mediation, both parties have to agree. There's no agreement until there's an actual agreement. But it is a great way to dealing with professionals and people in the service sector who may not have the time, may not have the money, may not have the appetite for war, and yet come up with a win-win solution. Yeah, I don't know if that helps.
Yeah, no, it does. And it for me, it re-emphasizes that creative solutions aspect that you were talking about, that so the mediation process helps and allows for the facilitation of that. You spoke about the mutual agreement aspect as it relates to mediation. So when it comes to enforcement, so say for example, there is an agreement. We have decided we are going to, so $10,000, I'm going to pay you $1,000 at the end of each month on the 27th by 2 p.m. How do we enforce agreements? So I may agree to that in the mediation session, and then I may go away, and then Anthony's trying to call me and I'm not answering Anthony's calls. So then what are the that you would help alleviate any concerns they may have around that?
Right. Good question again. So, all right. So there are a number of different ways we could look at this. So one way may be that this mediation occurred in the midst of litigation. The parties are already in court.
Right.
And so, and the courts, right? Our civil proceeding rules talk about the overriding objective about being mindful of court time and resources. And there's now actually a mandate on parties and their lawyers to try and settle matters as far as possible, use the courts as just a means of last resort. So if within the litigation, mediation occurs and an agreement is reached, well, the simple answer is you can make that agreement part of the court order. So you enter it as a consent order, and then there would be an actual court order that you could enforce.
Mm-hmm.
Now, we may not be in court. So this mediation occurred prior to court proceedings. All you have is the written agreement. Now, usually, when you write up these contracts, parties could say, look, we will keep this confidential. We don't really need to air dirty linen in public, but you can have a liberty to apply type of clause, whereby if one of the party breaches the agreement, you can sue on the agreement. So you would actually bring your claim and say, look, we had an agreement and he's breached the agreement. It's a lot easier than having to go and prove the substantive issue.
Right.
You understand? So you will go straight for summary judgment. And as I say, the third option is sometimes within the agreements, you could build in further mediation. And this is something that will typically occur, particularly in family settlements, where you have a lot of emotions and many moving parts that from time to time, somebody may stumble, something may not occur. Instead of building in mistrust and going from 0 to 100, you try to intervene and say, okay, what's going on here, and try and bring it back on track. So there are many options. Yeah. But the point I want to make really is that the soft skills I'm talking about, and this is something that, well, as you know, Siraj, I love ADR and mediation, not just as a part of my professional life, but I really think it is something that we need in the way we do things, the way we talk with each other. This is an opportunity to have some life skills. Yeah. And so one of those skills is the need to facilitate listening and speaking. And so in mediation, and one of the life skills that I would like to get defensive. You have to learn.
Right.
Yeah. You have to resist the urge to attack. We go quickly into, you know, a heavy response. So you have to learn how to change the conversation from the inside. When we talk, we mustn't talk down to people, but you mustn't also be so subservient that you can't talk, you can't speak truth to power. So you have to learn how to speak to the person, the other person's best self.
Right.
Key, fundamental in in these negotiations and for them to work is the ability to differentiate between needs, interests, and strategies.
Right.
Yeah. So in any kind of settlement agreement and any mediation, there are always three types of interests: the substantive interests, the procedural interests, and the psychological interests. And that is why the mediation designed as it was key. But emotions matter, feelings matter. And so we have to, in a mediation setting, to be able to see the emotions as signals. Yeah. Differentiate between acknowledgement and agreement.
Mhm.
The fact that I say, I hear you, I understand what you're saying, treats you with respect, it means I'm trying to communicate. It doesn't necessarily mean I'm agreeing with you.
Mhm.
Yeah. To be able to differentiate between evaluations and observations. Evaluations have a judgmental aspect, you know, but you must be able to say, look, I observe this, I observe that, without making an evaluation. This is very important again in relationships, whether it is partners, employer, employee, family members. We are quick to jump to assumptions. So again, a mediator is always going to test the assumptions. Well, why do you think this? Why do you assume that? You know, and you must be able to relinquish assumptions if they prove to be false.
Mhm.
So these are important principles. These are important skills. And for me, I think the best mediators have the gift of being able to change a conversation, how to reframe the issue. Yeah.
Right.
So how does that work? It works because you develop curiosity. Well, why do you say that? I get the feeling you feel this way. You want to tell me a little bit about that? You try to understand, and then you kind of move the conversation away if you see it going in a particular way. And you always want to assume that dialogue is always possible. Even if it seems unlikely, you have faith that we could talk through this thing. And you try to figure out what's happening, not whose fault it is. And now that's another thing in the courtroom is fault-based. One is right, one is wrong. But that's not how it always is in life. You know, and when you go into the fault mode, it's going to be problematic. You're not going to get a resolution. So you're trying to figure out, look, I'm sure both parties have had some kind of role in this. Let's try to figure out how we could solve it.
Right.
Very hugely important. Yeah. And then the last thing about mediation, and I think, again, we're talking about mediation, but these, as I say, these are skills that everybody in the civil sector should have.
Mhm.
Always look to the future. Don't get mired down in the past. You know, you acknowledge the conflict. You say, okay, let's try and see if we could sort it out. What's the real problem going on here? Let's assume that there are options to resolve this, even if we haven't discovered them yet. Let's try and work to solving them. And then again, you know, sometimes I see people, they want to be agreeable, they want to try and deal with the conflict fast, and they sign anything. Again, a good mediator is going to be very explicit about what you are agreeing to, make sure that we deal with the real issues and that you have an enforceable contract.
Right.
So, you know, you have to be explicit, and you have to be able to factor in things like changing circumstances and things of that nature. You know, and again, expect that there will be conflicts and plan for future conflicts.
Right. So I think that's a nice segue into the last question that I want to ask Anthony. So you spoke quite a bit about, from the conflict process, you spoke quite a bit about how you manage the process, how you would resolve the process, and you've gotten into in your last set of statements how to avoid, right? So appreciating that conflicts are going to happen, and what are some of the skills that you need as an individual to sort of mitigate the conflicts before they even begin, or before they even escalate further. So from a dispute avoidance perspective, what are some of the things from a business perspective, if you were to give advice to someone? So you mentioned building in the mediation clauses and things like that. So from that perspective, what are some tangible things an individual or an association in the service industry can actually do to sort of safeguard themselves from going direct to the last resort litigation aspect kind of thing?
Right, right. Well, that question triggers a philosophical response as well as a pragmatic response, right?
We welcome
So-
both.
All right, so let me just say, and I mean, we're talking about service sector businesses right now, but I would say we're talking also about Trinidad and Tobago. We're talking about all our institutions, right? How do you make an institution? How do you ensure that a business remains strong, viable, and enduring?
Right.
You know, the fact is, we don't pay attention to these things. And that is why things regress. That is why our institutions and our businesses fail, or they get corrupted, or they become incapable. We are generating a lot of instability by not paying attention to these soft but very important issues.
Right.
So the issue really is, how do you develop, how do you sustain the environment that supports your institution or supports your business? Yeah.
Mhm.
And we're talking about your capital, we're talking about your human resources, research capability. The fact is, we are not very forward thinking as a people. We always wait for a crisis and then we react.
Right.
So the philosophical approach would be, as Socrates said, don't wait for the crisis. The secret is to focus your energy not on fighting the old, but on building the new.
Yes.
Yeah. And again, too often we decide important things with feelings, not with the intellect.
Mhm.
So I would say you need to be strategic. You would need to make sure that in your service sector, you have proper contracts, upstream and downstream.
Mhm.
You have proper processes. You have the right network of people around you. Now, you know, the old days they say you should have a lawyer, a banker, and a doctor.
Right.
I would say you also need to have a dispute resolver,
Right.
yeah, to guide you. The same way you might need to have a PR man now. You know, the world is a lot more complex, so you need to have a network of advisors and supporters. And then you have to realize, okay, let's not be scared of conflict. Let's not run away from conflict. Let's learn to embrace conflict, because conflict, the Chinese have a saying, a kite cannot rise without an opposing wind. It is through conflict,
Right.
properly handled, that you reach your best self, that your businesses will prosper and thrive.
So Anthony, thank you for that. I think those are some nice parting words. So I just want to say thanks again for taking the time off to prepare this. I know I personally know how you feel about mediation, ADR, and its importance, and I know that you also have a passion for the service industry and creative industries as well. So we're very appreciative of that fact. And we're hoping to engage with you in a much more substantial, much more detailed conversation as we move forward. And in the same way that you've told participants to plan for the future, we're planning for the future with you in mind as well too.
Thank you, Siraj. Thank you,
All right.
Chris, and good luck with the rest of your webinar. Bye-bye all.
All right, bye. Thank you.
So I hope everybody is still there and watching on. I know it was a pretty long video, but it was interactive, so I'm hoping that you all enjoyed it. So Siraj, I'm just going to pass it on to you as we have like 15 minutes again.
Sure. Thank you very much, Christian. I just sent across an email with just 2 slides. If you can share that, I would greatly appreciate it. So I know that we are strapped for time. It's 1:13 by my clock. I'm going to try to keep this as brief as possible. We have indicated to the TTCSI that we would share whatever material we have available so that it can be distributed to the participants. I just want to sort of tie in what Sean has presented on so far and what Anthony sort of ended on, and that is in relation to conflict. So you have a dispute when conflict arises, right? To be better able to manage conflicts as it happens, 2, avoid conflicts, and 3, resolve them in a productive manner. You sort of need to have a base understanding of how we define conflict. So I'm going to give you the dictionary definition of conflict. So according to the Collins Dictionary, conflict is a serious disagreement and argument about something important. If 2 people or groups are in conflict, they have had a serious disagreement or argument and have not yet reached agreement, right? So you would notice that there are some words highlighted in that definition. So we're looking at the seriousness. We're looking at the fact that it is an argument. So you have opposing opinions. And fundamentally, and I think most importantly, the important aspect is something that we tend to not pay too much attention to. So from an importance perspective, when we're looking at conflict, we are looking at the value or the interests that individuals place on a particular situation and the as it relates to the dispute that they have ongoing, right? So just to expand a little bit more, so conflict arises when one or more of the participants decide that the status quo is not working, right? So what you have is that one party is sufficiently dissatisfied that they're willing to own the conflict enough to object to something. Sean spoke about it very early on that, when you engage in partnerships or engage in relationships, one of the things that you need to do is to have the courage to, 1, talk about how you resolve conflicts, if they occur in the future, but 2, when they do happen, actually have a voice and bring it to light. Otherwise, it's just going to get swept under the rug, and what's going to happen is that it's going to fester, right? So every form of conflict implies that there's a difference of perspective or perception, and they're divergent interests, whether or not the facts suggest otherwise. So when conflicts occur, generally what you tend to find is a me versus you situation. And it's all based on perception. I see things one way, and because they are not in alignment with what you see, I don't agree with it. So a conflict manifests itself there, right? Every conflict involves some degree of perceived incompatibility between the parties' goals and the interests. So there are dissimilarities in terms of what each party wishes to get out of the relationship as you move forward. All right. Touching on Anthony's philosophical side of it. So conflicts are fundamentally a result and a clash of belief systems, right? So different values. It can manifest as a result of change in power balance due to how we value the relationship. And often personal identities become intertwined with the interest under the dispute. So it's no longer about what we are upset about. It becomes who we are upset about. So I don't like Sean because Sean doesn't agree with me anymore, and she's always looking to curry favor with Christian, and she always disagrees with everything. That's the who aspect of it. The underlying aspect of it is, why do I feel that way? And the interest as is associated to that may be because of the relationship dynamics that we're experiencing. So it may not necessarily be directly related to Sean, but more so how the relationship dynamics are being manifested. When we think about conflict, people tend to think about conflict in a negative light, right? The reality, however, is that conflict is a normal part of relationships, and it can be positive when it is managed effectively. So my challenge to you is to actually think about conflict as a motor of change. It is something that ignites a question about the relationship dynamics and how we engage other persons. So transforming conflict into a constructive engagement requires a couple of things. It's about a clear focus about what you are trying to resolve. So again, not focusing on the who, but focusing on the what and the underlying interests. It's about having healthy communication between the conflicting parties. If someone decides that they are just going to avoid the situation, I'm upset with Sean, but I'm not going to let Sean know about it. What's going to happen is you're going to have oftentimes passive aggressive jabs happening. I may withdraw, I may not engage. What tends to happen then is that there's one fundamental deterioration of that one-on-one relationship. But on the grand scheme of things, it's going to have a exponential effect on the other relationships, inclusive of the projects. And when it comes to service industries, for example, B2B or B2C, relationships and reputation sometimes go very hand in hand. So when you have a dispute with a customer, for example, you don't want that customer posting something negative about you, on social media. If you are a service provider and you heavily depend on word of mouth, one person can, destroy the reputation and goodwill that you would have built over years of practice, depending on their power and or balance, and depending on the message that they show, right? So to manage conflict effectively, one has to develop the skill to understand how disputes start. Again, that's appreciating that conflict exists and focusing not on the who, but on the what and underlying interests, that they escalate, and they can escalate pretty quickly, but as it starts to develop, if you tackle it head on, you can actually transform the conflict. So what happens then is that the focus is on about understanding, among other things, what the underlying interests are, but from a relationship perspective, how the individuals involved in the conflict is affected by the dispute. Right. Chris, if you can just switch to the slide on the dispute resolution spectrum. Right. Thank you very much. So Sean and Anthony referenced heavily arbitration and mediation today, and they made mention of some other aspects of dispute resolution. Now, there is a dispute resolution spectrum. In the spectrum, moving from right to left, we are looking at methods that focus on ownership. So who has ownership in terms of dealing with the conflict, and then also who decides the result of it, and whether or not parties have to participate or there's a voluntary nature of it. So a range of dispute resolution techniques have been developed to facilitate the arrangement between the parties. These techniques can be used differently to achieve different outcomes, right? Again, the key is about understanding the nature of the conflict, whether it's interest-based, whether it's rights-based, whether it's an identity-based type conflict, or whether it's just a difference in understanding and perspectives. Right? By being able to analyze and understand how the conflicts start, you can then decide which dispute resolution method would be best for you. Now, when we talk about alternative dispute resolution, the general consensus is that it's everything outside of court and litigation. We have a belief that dispute resolution should include the court system. And the focus should not necessarily be on alternative, but on appropriate. So there are some instances where mediation is not not suitable, and there are other instances where you have to go to the court just because of the nature of the matter. So for us, the focus is on appropriate, knowing when to use the particular dispute method and how to use the particular dispute method, right? So if we look at the spectrum here, the dispute resolution can be categorized into levels, and the levels are determined based on the degree of control that the parties have on the outcome, right? It focuses on who has ownership of the outcome and the process itself. So how you go about managing the dispute, whether it is something that is voluntary, so the consensual part of it, and how involved you are in the process, right? So the diagram moves from the left to the right, so consensual to non-compulsory, and then the compulsory. What this demonstrates is a movement from constructive to contentious. So, Anthony was talking about that we are a litigious society. So on the extreme right, we're talking from the court litigation side of it. It is extremely adversarial. It typically leads to a complete deterioration of the relationships. And as service providers, relationships are one of the main things that you have to focus on for your survival, whether you're looking at the relationships with your clients or customers, whether you're looking at the relationship with your potential partners, or you're looking at the relationships with your suppliers. So say, for example, there's a dispute, a contractual dispute with your suppliers, but that supplier is the only supplier in your particular jurisdiction that imports a particular part of a raw material that you need for your product. If you have a conflict and it's not managed effectively with that supplier, there may be a relationship breakdown that is going to have a direct impact in your organization, your ability to service your customers, and ultimately your bottom financial line. So from left to right, left focuses on the win-win. So how can we both benefit from the conflict that we are experiencing? And on the extreme right, on the compulsory, it focuses on the win-lose type of outcomes. So I believe I am right, I want X, and I am not going to stop until you give me X. So I win, you lose, right? In deciding which dispute resolution choice to make, what you should consider is a value decision. And the value decision is about the impact or outcome of the dispute. So I just spoke about how from a relationship dynamic perspective, whether or not you want to participate in a more adversarial type conflict resolution process, or whether or not you value the relationship so much that you participate in a win-win type, consensual, voluntary, where you have control over the process type of situation. I'm just to give you a sense of what the different dispute resolution methods are. I'm just gonna read off very quickly sample description of what it is. So if starting from left, moving on to right, so from the consensual side of things, we're looking at negotiation. So negotiation involves direct talks between the parties, right? So it's a process that can be formal. You can have a formal negotiation. What's in it for me? What's in it for you? So what is my position? What's your position? And then how can we move along our positions to get to the best alternative negotiated agreement, right? Every aspect, again, the consensual part of it, every aspect of the negotiation is within the controls of the parties. You can decide who's involved, when you're going to have the negotiation, from an opt-out perspective, how long you're going to negotiate for, whether it's going to be 20 days, 1 month, 3 months. Otherwise, negotiation is just going to be going on and on and on. The other method that we can look at is the mediation. So when direct negotiations break down, the parties opt to relinquish some control, right? And the relinquishing takes the form of mutual agreement to bring in a third party. And that third party is referred to as the mediator, and that's a neutral third party. And what that mediator does is they're not going to tell you, what you should do. Generally, we're focusing on facilitative type mediation here. What they are going to do is they're going to take control of the conflict resolution process, and they're going to help you facilitate that process, discuss the positions, understand the underlying interests, generate possible options. The intention is for you as the party to retain full determination of the solution. So the mediator, again, is not going to tell you what you should or should not do. When we think about mediation, we think about it from the perspective of long-term sustainability. So more often than not, if there's a self-imposed solution, long-term sustainability tends to break down. If the parties mutually agree to particular things, then they are more often than not pretty comfortable with the resolution. And the harm that may have been done as a result of the conflict can easily dissipate, and that relationship can begin to repair itself as you move forward, right? From a conciliation perspective, this is when the mediator takes a more evaluative role. So the parties may have a general sense of what they want, but they can't make a decision on what it is. So the mediator in this instance actually provides a little more guidance in terms of the generation of options, reality testing those options with the parties in terms of whether or not they agree and if it's feasible. Control, again, coming back to that consensual side of it, control again still resides with the parties. So the parties retain the right to accept the ideas that have been generated or to reject them. All right. Moving along the spectrum, we have the non-compulsory dispute resolution method. So here we're talking about dispute avoidance and adjudication boards and expert determination. Dispute the AABs are typically used for construction disputes. If you want to know more about the AAB's construction disputes, Shan is your go-to person on that. She is an exceptional expert when it comes to these types of disputes, and she can provide specific feedback or guidance on those things, right? So DAABs are committees that are set up generally as part of the project when you engage in a construction project comprising of experts involved in the project, and more often than not, you would appoint a neutral third party, right? So when it comes to resolving any disputes as it relates to the project during the life of the project or arising out of the project, those disputes would be managed at the dispute avoidance and adjudication board level, right? So some control is relinquished there. Again, you have a third party or parties in this instance facilitating the dispute resolution. From an expert determination perspective, what you have is an independent expert, mutually agreed to by all parties. So this may be someone who has a significant technical experience. It may be an attorney at law. If it's an employment dispute, for example, you may bring in an industrial relations expert. And what they are doing is that they are being brought in to determine the issues of the disputed facts, right? You relinquish some control and the voluntary nature of the dispute resolution process when you utilize the expert determination. So it's voluntary insofar as you mutually agree to use an expert. It's the voluntary nature is removed because the parties need to agree beforehand that what they're going to do is to accept the determination by the expert, and they would abide by the findings as articulated by them. In some instances, what you can have is, as part of the neutral expert determination, is a non-binding neutral evaluation. So there's a level 1, which is a non-binding. First, I want to know, what are the facts? What is the situation? And if I were to take this further from a dispute resolution perspective, what would be my chances in winning? And that's non-binding. What you're doing is you're just trying to find some facts in that situation, right? If we move strictly to the compulsory side of things, so I'm not going to talk a lot about the arbitration. I know Shan touched on that there, I do want to say, like the expert determination, arbitration is voluntary to the extent that the parties agree to enter into arbitration. The parties agree to the appointment of a neutral arbitrator or tribunal, depending on the situation. The parties also agree to be bound by the rulings of the arbitration. So in certain jurisdictions, arbitration is regulated by two things, either legislation and or regulation within a particular jurisdiction, and then also international agreements that we would have signed. So Shan would have mentioned earlier the New York Convention. So Trinidad is a signatory to the New York Convention. A couple of the other regional islands are as well. Trinidad also has an arbitration bill that allows for the enforcement of international arbitration. In some other jurisdictions, so I know Guyana, for example, they haven't gotten to that stage where the enforcement aspect of it is covered in legislation. So they actually have to go before the court and make that an order of the court in order to recoup the awards issued in the arbitration. And then finally, litigation. So, you know, as I said earlier, litigation sometimes is unavoidable and sometimes you have to do it. What that does, however, it removes all the control from the parties. So what parties do in this instance is that they submit their dispute to the courts. They tend to go through their lawyers, and what they do is relinquish any role in the dispute resolution process. So how the process is managed, who determines the outcome, and how the award is decided, right? The fact of the matter is, and this is the last thing I'm going to say because I know we are 4 minutes over time. Thank you guys for staying with us till now. You know, conflict resolution represents an arrangement and for the future that the parties may support or benefit from a variety of reasons. So I'll end off again with you know, charging you to start to think about conflict differently, look at it from its change perspective, and the fact that conflict can actually be something that is healthy. And when you utilize the most effective dispute resolution mechanism, there can be a profound impact in the outcome of the dispute and the relationship dynamic, especially for members of the service industries. Yeah, so I will end off there. Christian?
Thank you, Siraj, for giving us that detailed presentation. So I'm guessing that we could send this, we will send this to Kavita and she will send off to the participants, right?
Sure.
But we do have some comments to record. Okay, just looking to see if we have any questions in the chat. So the video was sticking for some persons. I don't know, Kavita, was it sticking for you?
There were a couple points, but I will review when the recording is complete. Just to say, I don't know if you would like to send us the recording of that interview separate, so we can possibly upload that as a separate thing in the event that the recording is sticking. No.
Yeah, sure. We have the video, so I can probably try to send it via WeTransfer to the participants. And for everyone who registered and were not able to attend today, because we know that there were more persons registered that showed up, and we really want them to see the information that was presented. So Kavita, I will send that to you later, and I will send, well, right after this, I'll send you the slides. I don't know if Shan has anything to send, because I know she didn't present a PowerPoint, so.
No, I don't have anything to send you.
Okay, well, I think Kavita, I think we have gone on a little longer than we wanted to, but we know that the information was really critical. We wanted everybody to know this. So I'm hoping that you all benefited, and for those who stayed on, I wish I had something to offer you, but I don't. Maybe a cake next time. Kavita, so you can probably end off where I'm finished, and I'm very thankful on behalf of Dialogue Solutions for those who were able to attend today, and for the persons who can't and who is going to watch it at a later date, we missed you. And we would therefore, and we also wouldn't mind if you have any questions for us. Kavita, I know that you said you will give them our email addresses and some information. They can go to our website if they want to know anything about us. Feel free to send us some questions. We will send it to Shan. We'll copy Shan on the email, and Shan could respond to them directly. You know, stuff like that can happen. So just share the information with them, Kavita. Thank you.
No problem. And thank you all very much for, no problem. And thank you all very much for this session today. The information shared was quite informative, and we do appreciate it. Thank you all for joining.
It's been our pleasure. Thank you very much.
Bye, everybody.
you.
Enjoy your lunch. Bye-bye.